Okay, welcome everybody. Good afternoon. Before we get started, just a little bit of the administrivia. There is a door prize over there. If you haven't entered it, it will be drawn afterwards and then they'll contact you. Please mute, silence, do something with your phones. That way we don't interrupt our speaker. That being said, my name is Dr. Jamie LaValle. I'm a Muskeg Cree Nation citizen and an assistant professor here at the University of Saskatchewan Law. I'm pleased to welcome you to the second lecture of the 2022-23 academic year as part of the McKercher LLP lecture series at the College of Law. As we gather here today, we acknowledge that we are on Treaty 6 territory and homeland of the Métis. We pay our respect to the First Nation and Métis ancestors of this place and reaffirm our relationship with one another. I would like to begin by thanking McKercher LLP for sponsoring our lecture series, which allows the college to continue to present a wide range of informative, educational, and entertaining speakers to the law school community. I'm always like entertaining. Sometimes I'm like, are they going to juggle? I know I can't. Not putting that pressure on him, not at all, but I meant it's too late. Okay. But I'm pretty sure that we will find all of these together here, informative, educational, and entertaining. The Estey Chair in Business Law was established in 2012 by John and Bill Estey in honor of their father, the late William Bud Estey, former Justice of the Supreme Court of Canada. Their donation of $2 million is the largest ever private donation to the college. So note for when you guys become like lawyers, right? Chairholders are expected to teach business law courses within the college, conduct high-quality research in their field of expertise, and share their knowledge and insight by engaging in outreach activities with the wider legal community, such as the Estey Chair lecture today. The chair has been previously held by Kelly Jordan and Rod Wood, and is currently held today by Michael W. Milani, KC, who was appointed to a 6-month term on July 1st, 2022. To introduce our speaker is John Pringle from McKercher LLP, who is a proud alumni of the College of Law, where he received his LLB in, they're going to date him right now, 2000. They put it in here. Okay. John is a partner in the Saskatchewan office where he practices in the areas of securities law, natural resources law, and corporate commercial transaction. So please let's have a hand for McKercher.
Thank you, Professor LaValle. And I'd like to start by thanking the University of Saskatchewan College of Law for all their hard work putting together these lecture series. I'm particularly excited about this lecture and this speaker practicing in the area of corporate commercial law in Saskatchewan. And there's nobody better suited to give this presentation than Mike Milani. Michael is currently the chair of the executive committee of McDougall-Gawley LLP and is a fellow of the Insolvency Institute of Canada. Michael is also the chair of the Law Reform Commission of Saskatchewan. He has a wealth of experience from his broad banking law, insolvency, and commercial practice, including related litigation. He has appeared before all levels of court in Canada, including the Supreme Court of Canada, and Michael's research has appeared in peer-reviewed journals in Canada and internationally. Michael has been named by Best Lawyers Canada as Lawyer of the Year Regina 10 times in the fields of banking and finance law, insolvency and financial restructuring law, and banking and finance law. He has also been recognized by Benchmark Litigation Canada and Who's Who Legal Canada. Michael is the chair of the Law Reform Commission of Saskatchewan, and he is past president of the Law Society of Saskatchewan and was president of the Federation of Law Societies of Canada, which is the national coordinating body of Canada's 14 law societies, regulating 95,000 lawyers and 3,500 Quebec notaries. I would just add, in my personal experiences with Mike on Commercials Files, he is always exceptionally responsive, professional, and thorough. But even while advocating for his clients, Mike is always collegial and on more than one occasion shared with me advice on practice issues and work-life balance when trying to maintain a busy commercial practice. I still recall that advice to this day. He is a true credit to the profession, so please join me in welcoming Mike Milani.
Good afternoon, ladies and gentlemen. John, thank you for that very kind and generous introduction. And I was reflecting on the opportunity to deliver this lecture and on its sponsor, the McKercher Law Firm. And I recognized that the first lawyer I ever met was R.H. McKercher, KC, one of the senior lawyers of that firm. I was 9 years old, and I was a classmate, elementary school classmate of his oldest son. And then I reflected further and realized that Mr. McKercher was the only lawyer I ever met until I worked as a caretaker at the courthouse in Saskatoon in 2 summers when I was in university. There's actually another connection with my role here today. I'm very honored to be the current chair of the Estey Chair in Business Law. And I actually went to high school with 2 Esteys and played hockey with 1. And so it really is wonderful that the Esteys decided to donate as they did and to enable these sorts of things to occur and honor their father in that way. But it is interesting how things come full circle, at least for me. So why Saskatchewan? How can a province with a little over 1 million people be a leader in commercial law? Now, I'll explain why I hold that view, and I'll also describe why I think that occurred. So let's start by considering the Saskatchewan business landscape. Now, there are pockets of locally initiated commercial activity. We have a healthy energy industry. We have significant mining activity. And the agri-sector has never been more vibrant. But it's fair to say that Saskatchewan has not been a hotbed of commercial activity, which is usually what has to happen for commercial development in the law to occur. But why has Saskatchewan led Canadian jurisdictions in a number of important legislative developments in the commercial sphere? And those areas include developments in secured transactions, enforcement of money judgments, reviewable transactions, and potentially mortgages and other charges on real property. Why did that happen? And what ingredients were necessary? Was it some sort of primordial soup that allowed sophisticated commercial lending to spring to life here? Or some kind of prairie alchemy where the base metals of disjointed legal principles came together into Saskatchewan statute law? Well, I think the answer is a little bit less mysterious, but it actually is nonetheless remarkable. So my perspective. I'm sharing my observations that come from being a private practitioner in this province for a little over 40 years. And as John mentioned, I have a solicitor's practice, but I also litigate in commercial matters, including insolvency. And a large part of my practice is involved dealing with lawyers from other Canadian jurisdictions and non-Canadian jurisdictions. And those interactions actually help form my view of Saskatchewan's place in the commercial law batting order. And so it's through this practitioner's lens that I'm providing my remarks today. And my view is that there are several pillars upon which Saskatchewan's commercial law developments were founded. And I also believe that absent any one of those elements, although the developments may have eventually occurred, they would not have been timely, and Saskatchewan would not have led. Now, before we consider those pillars, some history and context is instructive. And I want to turn to debtor protection legislation. Some say that Saskatchewan is a debtor's paradise. Exemptions from seizure, special protections for guarantors, making farmers the most favored borrowers, realizing on mortgage security, no self-help power here, it's off to court, we must go. And actually, a not insignificant aspect of my practice involves advising colleagues across the country what can't be done in Saskatchewan, as opposed to what can be done. You can't do that here. And actually, it's a bit of a cottage industry for me and others who work in the area. And I can assure you, the first time that you advise an American lawyer that Saskatchewan has a Limitation of Civil Rights Act is an interesting experience. Now, they usually settle down when they realize that Saskatchewan has not overlooked the doctrine of emancipation, but it is an interesting conversation. And so I believe it's interesting to consider the development of Saskatchewan commercial law through the lens of this protective legislation that Saskatchewan has created. And let's start with the Limitation of Civil Rights Act. So what happened is Saskatchewan lawmakers reacted to dire economic conditions by enacting this very, very unique legislation. The government of the day concluded that Saskatchewan residents required protection from the punitive yoke of Eastern Canadian financial masters. Do you remember I said things come full circle? It's a little bit of that again today. So what did the act do? Well, it restricted the remedies of vendors of land and mortgagees who loan money to buy land to recovering the land. You couldn't sue for a deficiency. And sellers or vendors of personal property were similarly restricted to recovering the assets sold if the underlying debt was not paid. And then in respect of farm implements, the Act created an elaborate system of notices and court hearings, all as hurdles to be scaled before a lender could exercise remedies. So it's pretty easy for all of us to recognize that these provisions, if, among other things, eliminated the freedom that lenders and borrowers had to structure their business dealings without restriction. And through this innovative legislation, Saskatchewan significantly impacted commercial transactions in the province. A second example is the Farm Security Act. Now, this was 1944 legislation that stopped all final orders of foreclosure on farm homesteads unless certain things had happened, unless an order had been obtained from the Farm Land Security Board or the mortgage was security for the purchase price of the homestead. But beyond that, foreclosure actions were stopped and stayed in respect of homesteads. So once again, ordinary commercial relations were collared in by legislative prohibitions. And the concepts, of course, under the Farm Security Act have been subsumed and continued today in the current legislation, the Saskatchewan Farm Security Act. And the Saskatchewan Farm Security Act came into force in 1988 during the depths of the 1980s agricultural crisis. And the Act provided protection for farmers in the same manner as earlier statutes: stays, exemptions, court involvement, hurdles to realizing on security. But the Act also introduced a complex scheme of mandatory mediation between creditors and debtors. Not surprisingly, the lending community was extremely alarmed when this legislation came forward. But what they found is it created a forum to enable the parties to sit down in a non-confrontational way, for the most part, to engage themselves in a process that proved to be successful. And they were able to resolve their complex disputes in an orderly way. And I don't know the exact statistics, but if there were 500 farm foreclosures in Saskatchewan, my guess is that less than 20 actually went to court because people availed themselves of this opportunity. So again, debtor protective legislation, I actually think they are commercial statutes by another name. So how does all of that relate to Saskatchewan having sophisticated commercial laws? And how does it relate to my proposition that Saskatchewan has been a leader in commercial law? Well, in my view, the legislation, this debtor protective legislation, showed Saskatchewan's willingness to introduce novel, landscape-changing legislation that would significantly modify contractual relations. Now, each of those laws was enacted in response to a particular crisis. The policy goal was the protection of Saskatchewan residents. However, at their core, in my view, these acts were creative mechanisms to regulate commercial transactions. And it's also important to observe that although these new laws had the immediate effect of significant change and disrupting the ordinary course. The statutes themselves brought certainty to the outcome of commercial transactions. And so for those lenders and borrowers who came along later, the law and the rules and the risks were clearly articulated and understood. And predictability and reasoned risk assessment are hallmarks of sound commercial legislation. And so although the impetus of the laws was debtor protection, the approach that the statutes took was actually in harmony with the approach taken in more modern commercial statutes. And again, in my view, these old laws exemplify the willingness of the Saskatchewan legislators to employ statute law to regulate commercial activity and to achieve policy goals. And that willingness continues to this day. So, let us turn to more modern legislation. Now, as noted, and as I mentioned, in the case of the Limitation of Civil Rights Act and the Saskatchewan Farm Security Act, arguably nothing more than a little economic crisis was required to result in legislation. But that can't be said about the new legislation I'm going to refer to. That legislation was not driven by economic conditions. Something else was the initiator. And there are three more recent acts that I considered in reaching my conclusions. The first is the Personal Property Security Act of 1981 and its successor, the PPSA of 1993. Second is the Enforcement of Money Judgments Act. And third is the Reviewable Transactions Act of 2022. And there's actually a fourth example, which isn't yet legislation, and that's the proposed Land Charges Act. So, what are the pillars that induce these laws? In my opinion, in order for each of those acts I mentioned to have become part of Saskatchewan law, at the time they became part of law, for that to occur, the interaction of some or all of 5 elements was required. And these are my pillars. Now, in no particular order, at least as to importance, they are the Saskatchewan Law Reform Commission, the Ministry of Justice, academic engagement, the courts, and the practicing bar. So the commission, academia, the ministry, judges, and lawyers. First, the commission. In 1974, the Saskatchewan Law Reform Commission was created by an act of the legislature, and the commission's mandate is set out in the act. And I'm going to read it. The commission shall take and keep under review all the law of the province, including statute law, common law, and judicial decisions, with a view to its systematic development and reform, including the codification, elimination of anomalies, repeal of obsolete and unnecessary enactments, reduction in the number of separate enactments, and generally the simplification and modernization of the law. Well, that seems pretty manageable. So how does the commission go about its work? Well, the commission will select a statute or an area of law to study, and it will seek input from lawyers, the public, people in whatever community is affected. And then the commission will prepare a draft report, or may prepare a draft report for comments. And then ultimately it might prepare a final report setting out analysis, conclusions, and recommendations, and sometimes a draft statute. And that report is then delivered to the Minister of Justice and Attorney General. And one huge benefit of the commission's work is that its work is apolitical. It's not any one political party involved. But even more importantly, it's perceived correctly as being apolitical. And what that allows, it allows the government of the day to more readily place bills on the legislative agenda without fear of too much political debate instead of debate over the actual bill. In other words, the neutrality of the commission is a very, very important ingredient. What is the second pillar? Well, the second element, in my view, is the Ministry of Justice. And I recognize that it's kind of self-evident that ministry involvement is necessary for any law, including a commercial law, to be put into place. But it's really important, I think, to recognize that the ministry, through its legislative services branch, is actually a filter. It's the filter through which proposed legislation is screened before it potentially makes its way to the legislature. Now, creative ideas can be championed by the Law Reform Commission, but they can also die a silent death at the door of the ministry. Now, very fortunately, the ministry has welcomed proposals that modernize commercial law. Had that not been the case, it is possible that at least in some instances, the proposed legislation would not have become part of Saskatchewan law, would actually not have become part of Saskatchewan law. And I'm also certain that had the ministry not been receptive, Saskatchewan would not have been at the forefront of Canadian jurisdictions enacting such sophisticated legislation. The interaction between the first pillar, the Commission, and the second pillar, the Ministry of Justice, has been facilitated by one member of the Commission being a senior lawyer of the ministry. And in my time as a member and now chair of the Commission, those individuals included Susan Amrud, KC, and currently Darcy McGovern, KC. Each of them have a deep understanding of commercial law. They don't practice it in the private practice sense, but they are outstanding commercial lawyers and understand the benefit of moving the laws forward. So what about the third pillar? Academic engagement. Now, lobbying for changes to commercial law often comes from one or more stakeholders, and their justification for a change may be very sound, but their advocacy is often colored or perceived to be colored by their perspective. Stakeholders have a perspective. They have an axe to grind. By comparison, when proposals for change come as a result of legal research supported by critical analyses and academic rigor, they're not shackled by the specter of shareholder bias. And sometimes the academic input can flow directly to the policymakers. Other times the input comes from through the Law Reform Commission. And so just as my first pillar, the Commission, and my second pillar, the ministry, are linked, my third pillar, academia, is also linked to the first two. So how has the academic world contributed to Saskatchewan being a leader in the realm of sophisticated commercial legislation? It must be something in the water. The College of Law at this university has produced 3 of the leading academics in the Canadian commercial law field. Professors Ronald Cumming, KC, Rod Wood, and Tamara Buchwald. Tamara is my classmate hiding at the back of the room, I see. And so we've been blessed with these 3 individuals. And of course, Professor Cumming is a mainstay of this college. Professor Wood taught at the University of Alberta for decades. And Professor Buchwald has instructed at both universities, Saskatchewan and the University of Alberta. And their legal research and writings have been relied upon by the Law Reform Commission, the ministry, the courts and practitioners in Saskatchewan, and across the country and outside of Canada. It is very remarkable. Now, convincing the ministry and ultimately the legislators to introduce new legislation that fundamentally alters an area of law is not a simple process, but it is aided greatly by sound, in-depth, critical academic research. So we have to ask ourselves, what if those professors had not produced that work? Would Saskatchewan have had the same laws? And the answer is, at least in some cases, yes. But in my view, the introduction of laws such as the Personal Property Security Act would have been delayed. That in turn would mean that Saskatchewan would not have had a leadership role in the introduction of such legislation across Canada. And actually, in other cases, the answer is no to the question of whether Saskatchewan would have had the same laws without the academic involvement. In this category are the Enforcement of Money Judgments Act and the Reviewable Transactions Act of 2022. My next pillars I'll deal with together, the courts and the practitioners. So I've described the respective roles of the Law Reform Commission, the ministry, and academia. But what about the courts and the practicing lawyers? And one might say, well, how can they be pillars? Because after all, once a law is enacted, don't the courts and the lawyers simply help implement the law or apply the law? How is their involvement foundational? Well, having sophisticated commercial laws involves much more than simply creating legislation. The ways in which legislation is utilized, interpreted, and embraced or not embraced bear on whether the goals have been achieved. The judges and the lawyers are central to this process, and the early decisions by the court in respect of new legislation set the tone for the way in which the legislation will be interpreted going forward. They also influence the way in which the legislation will be used or avoided by the legal and business communities. So, you've heard my premise. How do we test that? We can test the 5 pillars by considering the acts that I mentioned. First, the PPSA. Personal property security legislation is multifaceted, but at its core, it's the goal of regulating commercial activity in respect of transactions involving security granted to lenders and vendors over personal property, that is, property other than real property. So was and is the Saskatchewan PPSA sophisticated commercial legislation? And was and is Saskatchewan a leader? Professor Cumming has stated the following, and I've paraphrased some of his words. The PPSA implemented in Saskatchewan one of the most modern regimes of secured financing law in the world. The Law Reform Commission undertook a project designed to reform the entire legal infrastructure for secured financing law. The Commission prepared reports containing recommendations and draft legislation that would provide a new law for all secured transactions and a modern computerized notice registry system. The PPSA proposed by the Commission contained many novel features which at the time were viewed as radical. Novel and radical. And with that, I completely agree. And so in answering the question that I'm asking today, how does the Saskatchewan PPSA fit? Is it really a leader? Professor Cumming noted that although the PPSA is not unique, there were novel features that have influenced well beyond the borders of Saskatchewan or Canada. The PPSA version of 1993 actually provided a model for every single Canadian jurisdiction other than Ontario. And those aspects that were considered radical in 1993 have actually been included now in the Ontario legislation, the New Zealand legislation, and also in recommendations put forward by the Law Commission for modernizing secured financing in England and Wales. All out of Saskatchewan, Little Saskatchewan. Saskatchewan leadership beyond its borders. So how did this sophisticated, radical, influential legislation come to be part of the laws of Saskatchewan? Well, let's consider my 5 pillars. The area was studied by the Law Reform Commission. A final report with draft legislation was provided to the ministry. There was extensive academic research that supported the Commission's recommendations. The report was embraced by the Minister of Justice. Had it not been so embraced, it is likely that PPSA legislation would not have come into Saskatchewan until many, many years after 1981. And almost certainly, the 3rd generation PPSA, the 1993 version, would not have first appeared in Saskatchewan. So those are 3 of the pillars: the Commission, the research, and the ministry. What about the courts and the practicing bar? Well, nobody loves change, least of all lawyers, and with respect, sometimes judges. So the PPSA came into force on May 1st, 1981, and I was very fortunate. I was completing my articles at a law firm then known as McDougall Ready Wakeling. There were 8 lawyers at the firm, but the most junior lawyer had graduated 4 years before I did. And as a result, that law firm, which was well known as a leader in commercial law matters, particularly banking law, knew nothing about the PPSA, except the articling student maybe did. And so for me, it really was the right place at the right time. And what it did, among other matters, it resulted in my being involved in much of the early litigation involving the PPSA. And that gave me a bird's eye view of how the legislation was embraced by the Saskatchewan courts. Just as the Saskatchewan practitioners were faced in 1981 with a sea change in the law, so too were the courts. And my own experience in the early 1980s was that the judges tackled the new laws and resulting issues with a lot of enthusiasm. And they actually did want to develop a deep understanding of the legislation. And my reflection is that the act actually was interpreted by the courts with the assistance of counsel in a manner that reflected the policies behind the act. And although Manitoba and Ontario had a PPSA in place prior to 1981, that was very much first-generation legislation. The more modern Saskatchewan legislation, the interpretation of it by the courts, the utilization of it by practitioners, in my view, all of those things encouraged other Canadian jurisdictions to implement similar legislation quickly, or slowly, but they did. And eventually we have PPSAs across the country other than in Quebec. And in my view, the courts were assisted by a core group of practitioners who worked in the area. And in the best traditions of advocacy, although they put forth their clients' positions, it was always against the backdrop of providing clear analysis to the courts. And those practitioners included, among others, Warren Spruill, KC, Rick Van Beesler, KC, Jeff Lee, KC, Joel Hesje, KC of the McKercher firm, now the Honorable Mr. Justice Donald Lay, and now the Honorable Mr. Justice Gary Mashishnik. We were always in court on one side or the other. Now, I recognize that even if the judiciary had been disinterested in the legislation, which was not the case, or if the court's analysis was, in some circumstances, faulty, the legislation would still exist. And by the way, when I say the analysis was faulty, I'm referring to cases I lost, just in case that's not clear. But the legislation would exist in any case. So is my proposition that the courts and the lawyers were pillars suspect? Did they really matter? And I stand by my view, including because the jurisprudence that arose from Saskatchewan in the early 1980s has been consistently and steadfastly followed by the courts of other Canadian jurisdictions and the Supreme Court of Canada. And I believe it's very important to recognize and observe that leadership in commercial law is more than simply creating statutes. It's the interpretation of that law by the courts with the assistance of the Saskatchewan lawyers, which reflects leadership both within and outside of Saskatchewan. Now, as an aside, I mentioned that I've had the benefit of a practice that involves Canadian or national aspects. And when I was working with Toronto lawyers on transactions or projects, it was always enjoyable to describe for them what I called the modern legislation. That didn't always go over well, but it was nonetheless a nice thing to be able to say. What's the second statute? Well, the second statute is the Enforcement of Money Judgments Act, or the EMJA. And that act truly revolutionized judgment enforcement law. Now, most of the prior law in Saskatchewan actually predated Saskatchewan becoming a province. It employed archaic terminology and outdated concepts, and it didn't provide for any cohesion between judgment enforcement law and the PPSA. The EMGA creates a near-complete code of judgment enforcement. It provides for exemptions and priority rules and pro-rata distribution of money among creditors, and also gives a judgment creditor the ability to have a status equivalent to that of a secured creditor under the PPSA. Very, very radical. And unlike the Saskatchewan PPSA, which had as its source Article 9 of the Uniform Commercial Code and the existing first-generation Canadian PPSAs, the EMGA was sui generis. It was new. It was not off the shelf. So how did this novel, sophisticated, radical legislation come to be part of the law of Saskatchewan? Consider my 5 pillars. The area was studied by the Law Reform Commission, and after consultation, it delivered its report to the ministry. There was extensive academic research, which provided the foundation for the Commission's report. The report was embraced by the Ministry of Justice. It didn't die a death at the door. And so, just as was the case with the PPSA, the judges tackled the new issues with enthusiasm, and with the assistance of practicing lawyers, quickly developed comfort with the legislation and interpreted it in a fashion that was consonant with its underlying policies. And you don't have to practice for very long to recognize that judges can go in the wrong direction. And frankly, it's most often the fault of counsel. But in these fundamental pieces of legislation, it was clear that the courts at the Queen's Bench, now King's Bench level, and Court of Appeal truly wanted to get it right. And if you look at any of those cases from the 1980s, I don't think you can read one without somebody quoting Professor Wood or Professor Buchwald or Professor Cumming. They really played an integral role to get it right, consistent with the policies at play. So what about the third act? The third act I considered is the Reviewable Transactions Act of 2022. And in May of this year, the Lieutenant Governor and Council gave royal assent to the act, but it hasn't yet been proclaimed in force. Now, the act replaced old legislation, very old legislation, the Statute of Fraudulent Conveyances of 1571. That's the law that was replaced, as well as the more recent Fraudulent Preferences Act. And the legislation came as a result of a joint project of the Law Reform Commission and the Uniform Law Conference of Canada. And their goal was to create a uniform act that would modernize Canadian provincial fraudulent conveyance and preference law. And the project was financed by the Law Reform Commission and quarterbacked by Professor Buchwald. Now, that report sat on the shelf for a long time. Any Canadian jurisdiction could have been the leader. The work was done. But Saskatchewan decided it would be so. And it's not because there were more fraudulent preferences in Saskatchewan or bad conveyances, or maybe there are and we don't know about them. But it was recognized that it was another opportunity where clarity to the law was appropriate. And so the Law Reform Commission reached out to Professor Buchwald to have her assistance in preparing an act that would be based on the Draft Uniform Act. And that's another very important feature of Saskatchewan commercial law, and why it is, in my view, we've been leading. We don't just take things off the shelf and use them. We adapt them and modify them as required to fit the Saskatchewan landscape. Now, there is a danger in that in commercial law, because harmony and uniformity is very helpful in a country like Canada where commercial transactions cross borders. But there are elements that need to speak to the local place. And Saskatchewan legislation has done that, and has done that with the Reviewable Transactions Act. So in 2021, the Commission issued its final report containing a draft Reviewable Transactions Act, which with slight modification became the Reviewable Transactions Act of 2022, the one that's been passed by the legislature but not yet proclaimed in force. No other Canadian jurisdiction, other than New Brunswick, has enacted modern fraudulent conveyance and preferences law. Why Saskatchewan? Was there a burning need to do that? Probably not. But it was recognized that it was another area of commercial law that was crying out for something more modern, crying out for change. And so Saskatchewan has moved forward. And so far, only 3 of my 5 pillars have been engaged in respect of this act. The courts and the practicing bar have not yet, of course, because the act hasn't been proclaimed in force. But I expect, as was the case with other commercial legislation, that the early treatment of the act by the judiciary, with the assistance of lawyers, will influence the speed by which other Canadian jurisdictions may implement similar legislation. So policymakers in those jurisdictions, lives are made simpler if there's operative legislation in another Canadian province that actually works, that actually has gone through court cases, and the policies intended have actually bubbled through to the surface. So I believe that Saskatchewan will again be a leader in the commercial realm in this area of fraudulent conveyances and transactions. The final area of statutory reform I will describe briefly is the Potential Land Charges Act. In May of 2021, the Law Reform Commission, employing the academic work of Professor Cumming, issued its report on the proposed legislation. And that act would turn the world on its head in terms of this type of law. It would modernize and rationalize Saskatchewan's real property law, which at the moment is found in a large number of statutes, many of which have inconsistent provisions. And so this law would, just as the PPSA modernized and rationalized personal property security law, and just as the AMJA modernized and rationalized judgment enforcement law, this law will do the same thing for land. And Saskatchewan's not the only province with land. I did a little research on that in advance of this. So why Saskatchewan? Why is Saskatchewan the only Canadian jurisdiction to attempt to weave together centuries-old land law into a coherent code that modernizes concepts of ownership and security, and at the same time, integrate that law with personal property security law and judgment enforcement law? Well, so far, again, this time only two pillars have been involved: deep academic thought and the Law Reform Commission. And if the proposal is to become law, it will require the imprimatur of the ministry. It can't die a death at the door. And in order for the law to be accepted as robust and accommodating legislation, and one to be adopted by other Canadian jurisdictions, that result will be aided once the Saskatchewan courts and Saskatchewan lawyers get their arms around it. Again, we will be a leader. So, what are the takeaways? What are the lessons learned, if any? Well, perhaps there are a few. I would say we've been very fortunate that the University of Saskatchewan College of Law and its graduates have been the fulcrum of progressive and deep academic analysis in the commercial law field. My own personal view, it's imperative, very important, that that continue. And we've benefited from the Law Reform Commission having included in its cafeteria of laws that it reviews commercial laws. And it has been very important that the judiciary and the bar have worked together to ensure proper implementation and interpretation of new legislation. And I submit that Saskatchewan would not have had its enviable platform of integrated, sophisticated, commercial legislation without the engagement of these five pillars. In conclusion, I would like to thank again the McKercher Law Firm for supporting the Estey Lecture Series. And John, thank you again for your kind introduction. I'm also very honored to have been selected as an Estey Chair of Business Law and to have had the opportunity to speak with you today. Ladies and gentlemen, thank you for your attention and good afternoon.
Sorry. So right now we'll do the Q&A for a little bit. Right now it's like 12:43. We do need to vacate about 1 o'clock. So one-part questions. Actually, a question.
Thank you. Thank you, Mike, for a wonderful presentation. I just wanted to touch on a fifth statute that I think we could maybe force into this discussion. That's the Commercial Liens Act of Saskatchewan. So in 2001, we were the first jurisdiction to bring this statute into force. British Columbia most recently has introduced a slightly modified version based on the national standard. I'm curious why you think Saskatchewan's the only place that's gone ahead with commercial liens legislation, kind of the flip side of the PPSA, we'll say, in relation to service providers.
Thank you, Professor, for that question. My belief is that once the PPSA came into place in 1981, that those involved in policy and creating other acts recognized that it was just one piece of many that had to fit together. And so if the commercial lien legislation had not been modernized, you would have a strange circumstance where cogs in the wheel were working well and you'd have an outlier. So my guess is that the research, including from folks like you, have inspired the Saskatchewan to act first. And so I'm glad you mentioned that, because I agree with you. It is another area of Saskatchewan leadership.
Good afternoon, and thanks for this wonderful talk. I think you're making academics feel vulnerable in our positions, because you come as a practitioner and give a very excellent academic talk. But my question is to, out of that combination of academia and practice, you've spoken about Saskatchewan exporting a lot of legislation and a lot of jurisprudence in some ways. And I'm curious on your perspective on if Saskatchewan has exported as effectively as it could legal services with an expertise on these matters, and if there are opportunities for Saskatchewan to realize more upon that expertise for the economic benefit of the profession and the province.
Thanks, Professor Newman. I would say that Saskatchewan has participated very well in organizations like the Uniform Law Conference. And in that fashion, Saskatchewan knowledge has been provided across the country. I also have the opportunity to work in my work with major Canadian law firms, and the Saskatchewan-trained lawyers are leaders there. And so I think that if I were a graduating student now and again, you can be shy about many things, but don't be shy about graduating from this college. And so I would say that there's more that can be done, but Saskatchewan has utilized avenues to provide that leadership. Now, I'm used to hard questions in the class I teach, so surely somebody's got something. Or not. All professors.
Well, I'm sorry. We never get the chance to ask questions of each other. We're always asking the students. So this was interesting to me. And some of the things that you said originally really resonated with me. And I'm just wondering, and this is more just me thinking out loud, maybe you can think about it a little bit too. The fact that Saskatchewan isn't the hotbed of commercial activity. We aren't Toronto, we aren't Vancouver. And so the idea of being able to do reasoned scholarship without stakeholder interference or political interference, and having this coming from the Law Reform Commission, from the ministry, picking up from academia, do you think that's actually one of the joys of being here in Saskatchewan, is we don't quite have the same maybe political pressures, so we've been able to enact legislation on a principled basis, as compared to always having to monitor kind of what other stakeholder interests might be at play?
I would say yes, but I challenge that in one way. What actually happened when the Saskatchewan Farm Security Act was being discussed in 1988 is that the Ministry of Justice brought in the vice presidents of the various Canadian banks, and there was some concern that the banks would turn off the credit in Saskatchewan. So one of the dangers actually of being in a smaller jurisdiction is that people can choose to ignore you. And so if any of this legislation had been viewed as unworkable, there would be a real problem. That said, I do agree with you that it's almost like, maybe a little bit like the submarine running underwater silently. Maybe this did allow us to put some things in place. And actually, I believe that the very lengthy time it took to modify the Ontario PPSA was in part because they could never stop meeting. There were so many people who had a stake in the fight.
Can I just ask a follow-up to that? And that was that. Oh, sorry. Okay. Sorry. Okay. Go. Thanks. So I was wondering about that too, in terms of financing drying up, in terms of not being able to, get access to credit because the lenders didn't like the PPSA or don't like some of the legislation that maybe Saskatchewan's putting forward. You said something that certainty is really important, and I agree. So have we got the right balance? And if we move forward with the new legislation with respect to mortgages or the Land Charges Act, is there more that we need to do in terms of I guess, making sure that lenders aren't fearful or would be hesitant to continue to be as robustly engaged in our provinces as they are now?
That's a great question, and I think part of the solution lies in firms like McKercher and our firm. And I'm not trying to pick out large firms, but those who have a lot of commercial expertise will do a great job of advising their colleagues across the country and their clients as to what changes are really being effected. And it's interesting, one of the simple things you can say to make lenders happy is you can use your old forms, because that's what they did with the PPSA. They said, it's going to call a duck a rabbit, but don't worry about it, just use the old forms. But your question is very sound, and I hope that if and when the Land Charges Act comes forward, that the ministry will take an opportunity to engage practitioners who can present seminars to ensure that the benefits of the Act are really understood, and that the small changes, or that the changes, we can all live with them if we understand them. Thank you for your question. So far it's professors and my law partners.
Hi, I'm Craig Krith. I work with Mike. I'm just curious, and maybe you can't answer this question. Like, if you go through all the acts that you covered, you've got kind of services, personal property, you got real property, you got judgment enforcement covered. From the law firm, like, what's the next hot topic from the Law Reform Commission, or do you kind of feel like a large portion of that is covered and you're moving on to other areas?
I'm glad you asked that question, because I wouldn't want people to gain the impression that the Law Reform Commission only works on commercial matters, and we're very careful to ensure that a lot of our work is more public-facing legislation. So it may be that there won't be commercial legislation coming forward for some time, and the focus will be more on other areas of the law. But the way you described it is good, because all of those pieces of legislation are very much public-facing. People have mortgages, people buy cars, and so that plus consumer protection legislation, which has been well handled by the ministry, really does cover a large portion of day-to-day events. The other piece I didn't mention today is that what Saskatchewan has been really good at is not being afraid to amend legislation. If a court decision comes out that is inconsistent with the policy, or if there are new developments in the law, Saskatchewans will pass an act to bring it up to date. And so just as the work doesn't end when the act is passed, in the sense that courts are involved, the work doesn't end because the law changes and the world changes. And we've been very good in Saskatchewan about keeping our statutes up to date in that way.
Thank you.
Thank you for your question.
Don't go away, but we have one of our students to come up and present our Estey chair with a gift. Did you have anything to say?
Yeah, just on behalf of students, the Speakers Committee, and the University of Saskatchewan, we wanted to thank you for taking the time to show us how great of leadership there is in the commercial legislation area. So thank you so much.
Thank you very much.
So once again, we'd like to thank the McKercher LLP for their lecture series here at the College of Law. And you guys can now leave. If you guys want to rush the stage, you guys can. However, there is a class happening after this, so rush the stage and then also leave the room. Thank you.